To the maximum extent permitted by the Constitution, the Attorney General shall vigorously prosecute those who violate our laws in ways that involve desecrating the American flag and may pursue litigation to clarify the scope of the First Amendment exceptions in this area. This is the dangerous part. This part, clarify the scope of the First Amendment exceptions in this area, basically means is the AG is going to start doing some test cases to clarify the scope, and what that means is they're going to try to overturn Texas v. Johnson. So that's one thing to notice about the Trump executive order is they're using some of these pre-existing holes, these categories of unprotected speech, as a hook to try to sanction some flag burning. Additionally, they're using the ambiguity of non-citizens' rights here. It's another issue we haven't really delved in. Who can assert these interests, right? Who can actually cite the First Amendment? Is it only citizens? And then this kind of vague notion of clarifying some of these exceptions. Some people think that Texas v. Johnson was wrongly decided, and they want to create a new category here and call that new category flag desecration. Hey folks, please like, comment, and subscribe, and make sure to check out my newsletter. Information is in the description. Another agenda item is the flag burning executive order that was issued by the current occupant of the Oval Office, Donald Trump. And that is purporting to punish people for burning a flag. I'm going to take you through this executive order. It's not very long, and we're going to see exactly what they're trying to say here and why they're a little bit clever in it. And by clever, I mean there are some legal arguments that one could see them trying to anticipate. And after that, I'm going to just give you a quick little rundown on how to address usual First Amendment issues. And so I'll take you through my process on how I view a First Amendment issue, most First Amendment issues. It's not going to be an exhaustive examination of First Amendment principles. It's just going to be something quick to give you kind of the nitty gritty of how I would sort of view any kind of typical First Amendment case. The executive order published by Trump, signed by him yesterday, by the authority vested in me as president by the Constitution and the laws of the United States, it is hereby ordered. Section 1 purpose. Our great American flag is the most sacred and cherished symbol of the United States and of American freedom, identity, and strength. Over nearly 2.5 centuries, many thousands of American patriots have fought, bled, and died to keep that stars and stripes waving proudly. The American flag is a special symbol in our national life that should unite and represent all Americans of every background and walk of life. Desecrating it is uniquely offensive and provocative. It is a statement of contempt, hostility, and violence against our nation. A statement of violence. Notice the words there. Statement of violence against our nation. The clearest possible expression of opposition to the political union that preserves our rights, liberty, and security. Burning this representation of America may incite violence. May incite violence and riot. American flag burning is also used by groups of foreign nationals as a calculated act to intimidate and threaten violence against Americans because of their nationality and place of birth. Notwithstanding the Supreme Court's ruling on the First Amendment protections, the court, that is the Supreme Court, has never held that American flag desecration conducted in a manner that is likely to incite imminent lawless action or that is an action amounting to fighting words is constitutionally protected. This is a true statement, as we'll get to in our little debrief, but I'll actually mention right now in preview. The reason why desecrations of flag that amount to incitement, right, that fulfill the Brandenburg standard, or that fulfill the Chaplinsky fighting words standard, the reason why those are not constitutionally protected is because, of course, they are included in categories of unprotected speech, right? It would be like saying any American flag desecration that contains sexually explicit images of children is not constitutionally protected. And they're citing Texas v. Johnson, which acknowledges these two categories of unprotected speech. They're already unprotected, right? If you have a desecration of a flag, which is CSAM, right? You just staple onto the flag explicit images of children that are unprotected speech. Of course, your desecration is itself not protected because it's encompassed by a category that is already unprotected. Hope that makes sense to you. So this is, in fact, a true statement by the administration, but it's obvious. It's like almost tautological. It's not, strictly speaking, tautological. It's just acknowledging that if a flag desecration is involved or is like the core part of another category of unprotected speech, it's not going to be covered. If you're using flag desecration as a method to incite imminent lawless action, or you're using flag desecration to fulfill the standard of a true threat, or to fulfill the standard of harassment, which are not protected, of course it's not itself going to be protected. That is logical and makes sense. It's just basically saying that incitement is not protected and fighting words are not protected. Though note that the fighting words doctrine is highly limited, and even in Texas v. Johnson, it's a very cynical and, I think, deceptive citation in Texas v. Johnson. In Texas v. Johnson, their citation to Chaplinsky and fighting words is basically saying, not about generalized political statements. It's about intimate words as between two individuals. And they cite again, right, like Brandenburg versus Ohio for the incitement standard to say, we don't want to have a more expansive, unprotected category for protection of the flag, because doing so would basically make a mockery of the Brandenburg standard. So it's a deceptive citation of Texas v. Johnson, because what the court was doing in Texas v. Johnson in citing those categories is basically describing the ways in which those categories don't apply to flag burning, and in ways in which they want to protect those categories by not making some more broad exception for the First Amendment that applies to the flag burning. This gets you a sense of, okay, well, if all they're trying to do here is virtue signal and just basically say, well, we're going to prosecute incitement and we're going to prosecute fighting words, they were already allowed to do that. So by its terms, it seems to be acknowledging the validity of Texas v. Johnson, at least this statement, this sentence, and doesn't seem to be changing, at least in this sentence, the amount of power the government has to restrict speech, because it's just citing already unprotected, categorically unprotected subsets of speech. But continuing on, my administration will act to restore respect and sanctity to the American flag and prosecute those who incite violence or otherwise violate our laws while desecrating the symbol of our country to the fullest extent permissible under any available authority. Again, by the terms of this sentence, right, what they're saying here is, to the extent permissible under our available authorities, if you incite violence and there's a desecration of an American flag, we are going to take a policy position in favor of like prioritizing those kinds of incitements over others. And that seems to be in general acceptable for the executive branch to do, is to pick and choose, right? This is prosecutorial discretion to pick and choose among which incitements, which ones to prioritize, right? We're going to be highly, no tolerance for criminal acts which involve the American flag. Again, by its terms, not something that appears to be illegal or not consistent with Texas v. Johnson just yet. Section 2, measures to combat desecration of the American flag. So that was the purpose. The general purpose here is to protect the flag. The Attorney General shall prioritize the enforcement to the fullest extent possible of our nation's criminal and civil laws against acts of American flag desecration that violate applicable content-neutral laws while causing harm unrelated to expression consistent with the First Amendment. This is, once more, language, and as we'll get to, taken straight from Texas v. Johnson. It's basically suggesting, what Trump is suggesting here is, we are going to prioritize anything that we can already target. That is to say, it is a government interest of ours to protect the flag. And so to the extent that flag desecration is caught up in acts which may violate content neutral laws without targeting expression itself or the communicative aspect of expression, that's going to be a priority. So once again, the terms of the executive order seem to be in keeping with Texas v. Johnson. This may include, but is not limited to, violent crimes, hate crimes, illegal discrimination against American citizens. Note this, right? So recall that one of the big priorities of the administration upon taking office was specifically to lessen the protections in terms of racial discrimination laws, frameworks, that kind of thing. But now they're attempting to use those theories and frameworks, and sometimes directly the statutes, to not protect against racial discrimination, but to protect American citizens, in their minds, from other kinds of hate crimes, I guess anti-patriotic or anti-American type hate crimes. So very sinister, in my opinion, morphine of these laws are here to protect the most vulnerable. That's what these civil rights laws, that's what these illegal discrimination laws were designed to effectuate. There's an anti-subordination principle, that is to say, to prevent subordination of an underclass, which was at issue in a lot of these frameworks and laws. And the Trump administration has perverted this initial purpose to serve the interests of an overclass, and oftentimes in bad faith. Even if you can sometimes find that these frameworks might apply in a context that would incidentally benefit, I don't know, protesters who are very patriotic, which I consider myself to be. It's a little bit telling, I think, that they're perfectly willing to throw those doctrines under the bus when it comes to racial minorities, but fine to use them when it comes to protecting Israel, the interests of Israel, or to do this kind of virtue signaling with the flag. And crimes against property and the peace, as well as conspiracies and attempts to violate and aiding and abetting others to violate such laws. So again, this subsection A is also, by its terms, consistent with Texas v. Johnson. B, in cases where the DOJ or another executive department or agency determines that an instance of American flag desecration may violate an applicable state or local law, such as open burning restrictions, disorderly conduct laws, or destruction of property laws, the agency shall refer the matter to the appropriate state or local authority for potential action. Again, this is also consistent with what is allowed under Texas v. Johnson. So you guys all saw the video of some guy burning a flag in the middle of DC, right in front of the White House. There could be local laws, burning restrictions that are neutral. Perhaps you need to get a permit for a burning. Perhaps in order to do a burning, it has to be in a designated area, right? Just because you have a right not to, there's an expressive protective element into flag burning doesn't mean the government can't regulate it at all. Of course, that would be ridiculous. So the guy who was arrested in DC, that might be a valid arrest. It's quite possible, and I'm guessing likely, that the guy who was burning a flag in front of the DC was probably violating. Again, I don't know it, I can't cite it, but my strong suspicion is you probably need some kind of super hard to get permit or something, or at least something you need to apply for, or maybe it's not even allowed categorically in front of the White House. I don't know the specific fire codes, the neutral fire codes, right? In the context of burnings near government offices and stuff. And just because you're not allowed to discriminate as to flag burning where there's expressive conduct and where you're targeting the communicative aspect of it, that doesn't prevent the government from having generalized laws against how you burn, when you burn. So don't take this kind of position. If you're in these conversations where you're having debates on First Amendment, you don't need to take the position. And again, I'm just in a second, we'll walk through how to analyze all of these issues. You don't need to take the position that you're allowed to burn wherever you want. Okay. You don't need to go that far. It's just the government can't target flag burning specifically to benefit the view that the nation ought to rally around the flag, that the flag is good for the communicative and expressive aspects of the burning. To the maximum extent permitted by the Constitution, the Attorney General shall vigorously prosecute those who violate our laws in ways that involve desecrating the American flag, and may pursue litigation to clarify the scope of the First Amendment exceptions in this area. This is the dangerous part, okay? Even though it seems innocuous, A, B, and A and B are just taking the view that the executive branch shall, as prosecutorial discretion, enforce the laws that already exist with extra prejudice when they involve desecrations of flags, which is well within the right of the executive to do. For better or worse, that is what the executive is tasked with doing. So A and B, and they're specifically citing either language or doctrines that are already unprotected. This part, clarify the scope of the First Amendment exceptions in this area, basically means what they're trying to signal is the AG is going to start doing some test cases to clarify the scope. And what that means is they're going to try to overturn Texas v. Johnson. So you should probably expect to see, and they're probably expecting that by issuing this declaration, this executive order, it will encourage people to do flag burning. They'll pick probably a particularly unsympathetic defendant, if available, to set up a test case to clarify the scope of the First Amendment, meaning we're going to try to narrow the First Amendment. Okay, so this is the part that should give you shivers down your spine. And you should not trust the Supreme Court for much of anything. If I had to bet, my guess is they would maintain Texas v. Johnson, but that is not a surefire bet. That's like a 60% confidence. Anyway, that's sub C. Sub D, the Secretary of State, the Attorney General, and DHS, acting within their respective authorities, shall deny, prohibit, terminate, or revoke visas, residence permits, naturalization proceedings, and other immigration benefits, or seek removal under these various different authorities, right? So some of these are grounds of inadmissibility, grounds of deportability, whenever there has been an appropriate determination that foreign nationals have engaged in American flag desecration activity under circumstances that permit the exercise of such remedies pursuant to the federal law. This is tricky. This will raise similar First Amendment issues. Well, do non-citizens have First Amendment rights? I think it's clear they do. There's binding Supreme Court precedent that says they do. And if there is First Amendment protected components to flag desecration, which I think that there are, presumably, I think what the right answer should be is that non-citizens cannot be discriminated on the basis of those protected activities. That said, be careful not to entangle the First Amendment analysis that we're kind of doing in isolation of the other areas of law which might apply, right? If you get charged with doing an illegal burn, perhaps that's a crime involving moral turpitude that makes you deportable or something. I don't know. And just because you burn a flag doesn't mean you're doing it legally in the other respects that we mentioned. That's basically it. So by its terms, the big things you can take from this order are, one, that within the government's already existing sphere of First Amendment carve-outs, fighting words, incitement, crimes against property, crimes involving illegal discrimination, crimes involving violence, conspiracies, attempt liability, aiding and abetting liability, that within these spheres of kind of excluded, already unprotected speech, the government is going to take an enforcement discretion position that will be highly prejudicial against individuals who use flag desecration somehow in the execution of these different laws. Of their acts which constitute the illegal conduct. And that's the kind of enforcement priority component to this. So the first part you should take away from this is within the already existing spheres of government regulation, government will take an enforcement discretionary priority or prioritization of targeting people who have flag desecration, flag burning as a component of their actions that are already unprotected. Number two, the DOJ or other agencies are going to, quote, clarify the scope of the First Amendment exceptions, which means they're going to try to push the envelope here, and they're going to try to limit what the First Amendment protects, obviously. And by the way, the enforcement discretion component that I referenced just before also applies to like referrals to the appropriate local authorities where it's outside of federal jurisdiction. And then finally, immigration, where the government has a lot more authority. They're going to push more on doing these kinds of First Amendment discrimination measures against individuals who are subject to the immigration authorities of the U.S. So that's the big takeaway here. You should expect test cases, enforcement priorities, and the application of immigration law for flag desecration. Notably, absent from the executive order itself, or like this like 1 year penalty notion. It's not here. And that could be just them talking. That could be like the punishment they're trying to seek out. Or that could be referring to like what they're going to try to enforce in their test cases. All right. Now I want to take you into the world of the First Amendment and to give you my general framework for how I address any kind of First Amendment issue. Now, I'm going to be excluding kind of form analysis. I'm going to be largely excluding viewpoint discrimination, and just want to give you some quick little tools, a quick little framework for how to approach First Amendment issues moving forward, where there is potentially some kind of direct regulation of speech. The first question that you're going to ask is it even speech or expressive conduct? First Amendment protects speech. And we read in the Texas v. Johnson case that the First Amendment, which states that the freedom of speech shall not be abridged, applies to the federal government and the state governments through the 14th Amendment. And it's not just literal spoken word or written word that is protected. It's broader than that. And to the extent that you're not dealing with like written or spoken word, you might be dealing with expressive conduct. And to decide whether or not some conduct is expressive to get First Amendment protections, you apply the Spence test. The Spence test, which is that the speaker intends to convey a particularized message, and the message is one greatly likely to be understood by listeners or those who view it. A great example of this is wearing a black armband in the context of the Vietnam War. That's not literal spoken word. It's not literal speech. It's not literal typewriting, but it is expressive conduct. The speaker intends to convey a particularized message, and these armbands are likely to be understood by the listeners or those who view it. That's the Spence test. And if we're not dealing with speech, it's not a First Amendment issue, right? So this is your first funnel. Again, I'm not doing a totally comprehensive look at the First Amendment, just the kind of direct regulations of speech. So I'm not really dealing with viewpoint discrimination as much. But yeah, so if we're not dealing in terms of these direct regulations with speech, it's not a First Amendment issue. So take, for example, like drunk driving. It's an example I like to use. Or like shooting a gun at a crowd. You know? These are not literal speech, and very unlikely that this kind of conduct would fulfill the Spence test for expressive conduct that would get First Amendment protection. So there's no First Amendment issue if you get charged with drunk driving. There's no First Amendment issue if you get charged with, like, murder. Now, you can maybe imagine a situation in which shooting a gun might be expressive conduct. Let's say that you're doing some kind of act, some magician's show or something, and part of your act is shooting a blank or something. You can start to, or shooting a gun is part of your movie that you're making. You can start to see how you might marshal some arguments that, in certain contexts, even something like shooting might be expressive conduct in the right context. Next, for these kinds of direct regulations, 2, if it's speech, right, is the restriction content-based? Are we regulating the speech or expressive conduct based on the content of it? Does the harm of the speech or the harm that the state is seeking to alleviate, does it grow out of the fact that the defendant is communicating or the way people can be expected to react? Does it have to do with what the speech is saying? So a good point of clarification here is the case O'Brien. O'Brien is the case cited often in the Texas v. Johnson decision on the flag burning. This is the draft card case where they were burning draft cards. Well, is burning a draft card intended to convey a particularized message? Yes, probably. Is burning your draft card likely to be understood by listeners or those who view the conduct as having a message that's understood? Yes. So in O'Brien, we have expressive conduct, but is the government regulation on the draft cards as construed by the Supreme Court, is that a content-based restriction? Well, the government said no. The reason we're banning burning your draft cards is to keep the records well, right? And to manage our selective service program well. So if we have people burning their cards, we can't manage the shit. So the second funnel is going to be seeing, well, is this a content-based restriction or is it not a content-based restriction? And once you get into this kind of content-based, not content-based, you can follow 2 kind of tracks. The first track, you might say, if it is content-based restriction, apply one or more of the categories. So this would be step 3. If it's a content-based restriction, check if any of the categories of unprotected speech apply. If not, strict scrutiny, highest level of constitutional review. If it's not a content-based restriction, apply the O'Brien effects test or time, place, and manner restrictions. So this is your funnel. And you kind of have this little mini tree. If it's a content-based restriction, something like this, the reason we're restricting your speech here is because you're inciting people to imminent lawless action. Okay, so it is a content-based restriction because it has to do with what you're saying, right? Changing what you say changes whether we restrict you. So it's clearly a content-based restriction. But incitement happens to be in a category of unprotected speech. And here you can put in all your categories: incitement, defamation, true threat, CSAM. Another one is obscenity. These are all your different categories of categorically unprotected speech. Fighting words. So these are your categories of unprotected speech. Another one here you might include here, although query whether you would do this, but I have to check on this. Material support. I don't know if this is actually the correct analysis, but material support for a terrorist organization. Maybe you construe that as a category of unprotected speech. Maybe you say it's not an expressive conduct at all, so it's not protected. Let me follow up on that. But in general, so question mark, material support, whether that's one of the categories of unprotected speech or does it arrive at a different point in the analysis? And that's your kind of funnel. If it is content-based and is not within one of your categories of unprotected speech, then you apply strict scrutiny. And then it's a content-based restriction on speech. And it's the highest level. It requires a compelling purpose that's narrowly tailored. That's strict scrutiny. If it's in a category of unprotected speech, you apply the test of that category. And if it's successful, right? Basically it's going to be unprotected if it fits one of the categories applying that test, right? So you apply the test for obscenity. You apply the test for CSAM, right? You apply the test for incitement. This is Brandenburg, right? You apply the test for defamation. What are the First Amendment principles of defamation? The New York Times v. Sullivan. Now, defamation is usually a state tort, but you understand, right? The First Amendment doctrines that are pertinent to defamation. For fighting words, you apply Chaplinsky. So you apply the test of the different category of unprotected speech. First Amendment is very complicated doctrine in many ways. There's a lot of it's like Swiss cheese. There are a lot of holes, and it can be hard to keep it all in your head. And this is just the framework. I'm not claiming to be totally comprehensive here. I hope it's helpful. Maybe there's a category here for school stuff where there's less First Amendment protections within school. So you're doing some kind of content-based restriction, but it relates to school. And the court might not construe it as this kind of funnel system, right? Sometimes the court seems to be more methodical and analytical about what it's doing. So sometimes it's very helpful, but here I'm just giving you my framework that I learned in law school and has generally been my go-to. All right. So if you're in one of the categories, apply the test from the category and apply the result from the category. If not one of the categories, strict scrutiny. Okay. If it's a non-content-based restriction, then we're in the world of either O'Brien. So it's not content-based restriction because it's conduct and it just has an incidental effect on speech. We're not going after the conduct because of its communicative aspect, right? We're not going after the draft card because of communicative significance. It has to do with the way you're communicating, or it has to just be some sort of after effect of your communication. So think about in O'Brien, if you had a regulation like no burning anything because burning is just too dangerous in this zone. Well, that is not intended to go after speech because of its content. You're just going after burning. Now, as it happens, it will have some effect on speech. So apply O'Brien. And the test in O'Brien, you don't need to memorize this, but does it further an important or substantial government interest? And is the incidental restriction on First Amendment freedom no greater than is essential to the furtherance of that interest? So there needs to be an important or substantial interest in O'Brien. So here you might think a normal fire ordinance might pass O'Brien. Another way something can be a non-content-based restriction is if it's a time, place, and manner restriction. And in a time, place, and manner restriction, it is kind of targeting aspects of how the speech is happening. Time, place, and manner applies to the laws that regulate speech itself. But it's not really regulating it because of the content. It's just you're out at 9 p.m. on a megaphone, right? So a normal time, place, and manner restriction might be no loud noises after 8 p.m. Park closes at 8 p.m. So it's not a content-based restriction. It's like, again, a time, place, or manner restriction. It's a reasonable time, place, or manner restriction. And the test here is another form of intermediate scrutiny, similar but not exactly the same as O'Brien. You need to have a narrowly tailored restriction to a significant government interest compared to a important or substantial government interest. So query whether those are different. Time, place, and manner, significant. O'Brien, important or substantial. I don't know. And there's an additional thing for time, place, and manner not present in O'Brien, which is you need to leave open, quote, ample alternative channels for communication. So in O'Brien, you have important or substantial interest, and you have, in terms of the tailoring, right, no greater than essential to furtherance of interest. For time, place, and manner, you have significant interest, government interest. You have to have narrow tailoring, and you have to have ample alternative channels. Both forms of intermediate scrutiny. And of course, if it's not speech at all, we're dealing with rational basis review. And in the categories of unprotected speech, they're just unprotected. So, rational basis. That's the kind of framework. Now, why don't we apply it to some of the examples that we've talked about over the course of the last few weeks? First, let's do the flag. We'll run this with the flag burning. Is flag burning expressive conduct? Well, sometimes yes, sometimes no. If you're burning a flag to dispose of it, which is sometimes a way to dispose of a flag, Congress has passed what are known as precatory regulations on how to maintain flags that are not necessarily binding on normal citizens. But some flag burning certainly is expressive conduct. So don't just say all flag burning is. Only some is. But if your intent is to convey a particularized message, and if your message is one that's greatly likely to be understood by listeners or those who view it, it's expressive conduct. All right, so we have the kind of political-based protesting of burning a flag. That's going to be protected as expressive conduct. Now, imagine that the government passed a law that said no burning of flags if the purpose of the burning is to degrade, the character of the nation or to undermine the national unity of the flag. That law would be content-based. Or if you said something like this, no burning the flag as a protest against the government. You can burn the flag to dispose, but any flag burning that is done in conjunction with a political protest is illegal. That would be a content-based restriction. And if it's a content-based restriction, we go to a categories. Well, is flag burning any one of these categories of unprotected speech? No, not by itself, no. So we apply strict scrutiny, and the regulation almost certainly fails. Now, if you have a general rule that says, no burning of any article of clothing or any cloth item, okay, well then the restriction could definitely affect some speech, but it's not a content-based restriction. Okay, apply O'Brien. Is there an important or substantial interest? Maybe in some cases, yes, right? The restriction, no burning in a zone in which there have been a lot of wildfires. So there's a very substantial interest there. And is the restriction no greater than essential to the furtherance of that interest? Yeah, we really can't have any burning in these designated zones. Maybe that's a different analysis if you're in a place where there's never been a wildfire. So now you can say, okay, the restriction only covers near buildings. You need to be at least 200 feet away, and you need to have a permit to do a fire so that the fire people can be around there. Okay, so now we have a restriction that isn't content-based, but it's advancing a substantial interest of not having having safe fire. And the restriction is tailored in such a way that we can allow for this speech while maintaining the interest by having a permit that puts the firefighters on notice or something. Okay? That's maybe how you would apply it. Another example, right? Let's say that someone said something like, well, if you really cared about Medicaid, you would do X to Senator Rick Scott. And someone tried to say to you, well, that's banned speech. That's a true threat. Or if you said something like this, something like, I think that it's justified as a valid military target to go after someone's wife who is, doing some kind of work for the IDF. Is that speech? It's not even expressive conduct. That's directly speech. Okay. Would banning that as a threat or saying that speech is not allowed or sanctionable by the law, is that a content-based restriction on speech? You betcha. Right? that whether or not we ban the speech turns on what the message is of the speech. The fact that you're suing this hypothetical of Rick Scott comment or comment about your favorite creator's wife in the IDF being a valid military target, whether you're restricting that absolutely turns on its expressive communicative significance. And so it's a content-based restriction. And so that's why when I get into these debates, I'm like, what's the category of unprotected speech? Does it fulfill Brandenburg incitement? No. Does it fulfill true threat? No. Is it obscenity? No. Right? And if it's not any of these things, strict scrutiny applies. Now, what has Trump done in his executive order? Trump has said, right, to the extent that flag burning is already covered in these other doctrines, right? Incitement. Put here also, by the way, like property crime, conspiracy. These are other categories. Like, just because you have the speech in a conspiracy doesn't mean that that's like protected. You can't do a criminal conspiracy just because you like said words as part of it. Trump, and part of the executive order, is saying if there's flag burning within one of these boxes, we're going to go after it. Well, he's entitled to do that, right? Or presuming that, everything else is on the up and up. These things are already unprotected, so there's no problem there. If you're targeting flag desecration contained within incitement as a matter of executive discretion, prosecutorial discretion, that's well within the rights of the executive to do. Keep in mind, sometimes there can be issues of over and under inclusiveness. So if you pass a law that said something like this, that like, okay, incitement is only a crime for Republicans, then you can have an under-inclusiveness problem, which, the law itself is unconstitutionally doing content-based restrictions. So there are other nuances here. I'm not just saying that like the government is free to discriminate based on political preference in all of its laws, but in general, in terms of the execution of law, in terms of prosecutorial discretion, it's within the president's right to do that. So that's one thing to notice about the Trump executive order is they're using some of these pre-existing holes, these categories of unprotected speech, as a hook to try to sanction some flag burning. That's a legal hook. Additionally, they're using the ambiguity of, I don't think it's that ambiguous, but the ambiguity in some people's minds of non-citizens' rights here, right? That's another issue we haven't really delved in. Who can assert these interests, right? Who can actually cite the First Amendment? Is it only citizens? Can it be a domestic corporation? Can it be a foreign corporation? Can it be, someone at the border? What about someone who's in the interior of the country who's a resident alien? So they're using the ambiguity of the non-citizens' rights under the First Amendment, and then this kind of vague notion of clarifying some of these exceptions. So using the exceptions themselves in the order, appealing to the immigration laws to push the boundaries on non-citizens' rights under the First Amendment, and then this notion of clarifying some of these categories and potentially including as an additional category, which is what some people want to do. Some people think that Texas v. Johnson was wrongly decided, and they want to create a new category here and call that new category flag desecration. A lot of lefties want to have a new category too. Call that hate speech laws, unprotected hate speech. We currently don't have hate speech exception to the First Amendment in this country. I think that's a good thing, frankly. But you can imagine some left-wing people saying that should be an exception. We should have a category of unprotected speech, call it hate speech. Or if you're, more nationalist, you might say we should have a category of unprotected speech, call that flag desecration, which currently was rejected in Texas v. Johnson. So that's my framework for, again, it's not comprehensive. There are things that I'm omitting here, nuances that are beyond the scope of this review, but I hope that's helpful. And just one more time to summarize, step one, is it speech? Is it even protected by the First Amendment, or is it expressive conduct? How do we tell if it's expressive conduct? Use the Spence test. If it is speech or otherwise protected, right, or expressive conduct, is the government restriction at issue based on its content, on the communicative significance of whatever it is that's being expressed? If so, go to non-content-based funnel. Sorry, if not, go to non-content-based funnel. If so, go to content-based funnel. In content-based funnel, apply any one of the applicable categories and their respective tests. And if none of the tests fit, you're in strict scrutiny land, the highest level of analysis. If it's a non-content-based restriction, apply either the O'Brien effects test, which has to do with, when the regulation at issue isn't targeting conduct because of its expressive elements, you just need to show that there's important or substantial interest, and that the regulation is no greater than essential to the furtherance of that interest. If you were a non-content-based restriction because you're just regulating the time, place, or manner of the speech, apply the time, place, and manner test. And that test deals with a significant interest. It has to be narrowly tailored. That leaves open ample alternative channels for expression. These are both forms of intermediate scrutiny. Their distinctions are kind of not totally clear. It's just our best way, my best way of trying to represent the different formulations here. And anything that's either not, speech or one of these categories of unprotected speech, you're going to apply rational basis. So content-based without any categorical exception, strict scrutiny. Non-content-based, which is either O'Brien effects or TPM, intermediate scrutiny, and any category of unprotected speech, rational basis. Same thing with non-speech. Does that help? It does, says Oliver. Well, I'm glad. Clear to me. Awesome. And if we actually go to, just real quick, Texas v. Johnson, you'll see them citing these cases. US v. O'Brien, outside of the O'Brien test, the Spence test, right? So they're actually using these doctrines. We first determine whether it was expressive conduct, right? Isn't that what I said here? Is it expressive conduct? And in one of these footnotes, I think they say that, sometimes desecration is not expressive. So the court is actually using these doctrines and applying them. I'm confused. How is this related to Hassan Bad? Well, if you apply this to some of the Hassan Bad discourse, it can be really super helpful. Apply it to the alleged threats to Ela Klein. Apply it to the alleged threat against Senator Rick Scott. I think both of those are quite easily content-based, proposed hypothetical restrictions that don't meet any of the categories of unprotected speech. And so you would apply strict scrutiny. Think about the statements in favor of the Houthis, right? If you were to regulate generalized advocacy in favor of the Houthis and say the government can restrict you from saying that, or impose some penalty. Well, is that speech? Yes, it's speech. Would restricting it based on your support of the Houthis be content-based? Of course. You're restricting it based on commutative significance of being in favor of the Houthis as opposed to against them. Well, is support for the Houthis, generalized independent advocacy in favor of the Houthis, is that covered by any of the categories of unprotected speech? Probably not. No, not at all. It's not incitement. And keep in mind also, these tests used to be a little different. Especially incitement. This used to be a much lower standard. It used to be, it could be a crime to be a member of the Communist Party. Why? Because the Communist Party advocated in abstract the violent overthrow of the United States government. So the old tests, the Dennis test, the Schneck decision, right? These old tests before Brandenburg, just joining an organization that in abstract advocated for the violent overthrow of the U.S. government, the government could punish that as a crime, as incitement. That no longer exists. In order to fulfill Brandenburg, you need imminence, you need intent, you need inciting words, and you need a propensity. Some people split the test up differently. I kind of view it as 4 different factors for the incitement test. But there you start to notice the structure of the analysis at issue here. And you're just not going to fulfill the imminence requirement by saying, oh, I like the Houthis, or saying Houthis are base, or even saying, it would be justified for someone to kill even a specific person. If someone is allowed under the First Amendment, I'm not advocating for it. I'm against this. But there are some people who would say, not only would I support it if it happened, I think it would be good if something bad, if someone did something bad to the sitting commander in chief. I'm not saying that, by the way. I'm just saying there are those who could argue that, and I don't argue it. I don't support it. But there are those who could, and that would be protected speech. Now, if you actually entered into a conspiracy to do some kind of act, that's different. That's not protected. If you went up to the president's home and so you had imminence, right? You're right there, proximity. You say, you guys go over there and do something bad right now to a bunch of a crowd that is apt to hear your message. Well, now you have intent. Now you have imminence. Now you have inciting words, and now you have a propensity that it will actually occur. So now you have incitement. But it's useful to have the framework, like I said, because it allows you to think about how you would approach some of these public controversies. And I see this idiot in the chat. Sorry. He's like, yeah, the Brandenburg Standard is an exacting standard. It allows people to have this kind of innuendo sometimes. And if you can't prove beyond a reasonable doubt intent, imminence, inciting words, and propensity, it's just going to be tough. And that's the price of the First Amendment. I said this in Tim Pool's, the thing I did in Tim Pool when we were talking about Mahmoud Khalil. Or it was Kilmar. I said, freedom isn't free. I stole that from a bunch of different sources, I guess, but Team America's is a very memorable song there. Freedom isn't free. Having a robust and strong First Amendment definitely has costs. Like, this is not good speech to say, to lie, right? Lying is not good speech. Hate speech is not good speech. I would prefer if people didn't have hate speech. I would prefer if people didn't lie. I would prefer if people didn't have this kind of wink, wink, nudge, nudge to Hamas. I would prefer that. And I suppose by having a free society, you're taking on the costs of tolerance of such speech based on the policy-based reasons to support free speech in the first place, which are perhaps the notion that sunlight is the best disinfectant, perhaps the notion in the free marketplace of ideas, perhaps as a safety valve for democracy. We don't trust the government to be making these choices. That's one that's very, of high salience to me. I don't trust Trump or Obama or Biden to decide what is fit for consumption, what people are allowed to say. So I have a big fear of authoritarianism, which is one of the reasons why I think the First Amendment is a good idea.